American crypto is unclear. Businesses like Ripple are considering investing abroad as a result of the policy. With the recent release of documents related to the Hyman speech, the ongoing legal action by the U.S. Securities and Exchange Commission, SEC, against Ripple Labs has reached a critical turning point. All eyes are now on Judge Annalisa Torres for the eagerly awaited decision. Brad Garlinghouse has claimed that Ripple co-advised the U.S. to follow the U.K. and Singapore. Before I go on with the video, please kindly like and subscribe to be updated whenever we post similar videos like this. Thank you, and let's continue with the video. The Hyman papers essentially indicated that Ethereum is preferred above other cryptocurrencies in terms of security. Hyman stated that after being issued as securities, digital assets may change. XRP investors are currently dealing with the Ripple litigation station based on the same principle. In March 2023, Judge Torres ruled on the parties' respective applications to exclude expert witness evidence. Although a decision was made in March, the summary judgment has not yet been issued. Judge Torres has often required less time than this between dog-bear decisions and summary judgments. May soon be resolved. Curiously, the U.S. Federal Reserve will formally available every day of the year round. The clock. Finestra Volute Technologies, one of the banks taking part in the July 1 launch, and Ripple partners worldwide are significant examples. Given how things are turning out, July 1, 2023 may prove to be a turning point in Ripple's legal battle with the SEC. Some in the cryptocurrency community have hypothesized that the final ruling in the Ripple litigation needs to be issued before the launch of the Fed Now service in order to assure complete legal compliance. The future of regulation of all digital assets, not only Ripple, could be significantly impacted by this day. Hence, the crypto industry is closely monitoring it. Ripple Labs' lawsuit against the U.S. Securities and Exchange Commission stands out in the ever-evolving realm of crypto regulation. Ripple is the company behind the XRP cryptocurrency and has been involved in a legal conflict with the government since December 2020. As the trial draws to a close, Brad Garlinghouse of Ripple CEO has emphasized the need for ongoing efforts to understand the sector. The CEO of blockchain creator Ripple, Brad Garlinghouse, has been a vocal supporter of standard crypto market regulation. He contends that a clear framework is necessary for the growth and profitability of firms as well as the Garlinghouse thinks that American business people and investors may look abroad for opportunities and that restrictions are needed to safeguard them. Maintain market integrity, but he emphasizes the necessity for a compromise that enables creative problem solving while simultaneously addressing genuine concerns. Hyman documents were released on June 13 as part of the ongoing litigation between Ripple and the SEC. The same day, Garlinghouse filed a complaint against the agency and posted a video on Twitter explaining what had happened. Garlinghouse warned that this is just the beginning of a much larger dispute for the industry and that the fight for regulatory clarity must continue. Garlinghouse claims that the SEC purposefully caused uncertainty in a film posted on June 17 that uses the Hyman document. The lawsuit against Ripple was first brought in December 2020, which was a very Grinch-like touch since it was days before Christmas, as he put it. This is the very definition of putting power and politics over people and good policy in his defense. They used that confusion about the rules and they used it through enforcement. Garlinghouse in his address condemned sex actions as bad faith, plain and simple. Garlinghouse asserts that he was never aware that the excerpt was classified as a security and that he responded to all. Even if the Ripple SEC issue is quickly resolved, clarity is not yet complete. It's good that the case has sparked discussions and debates about how cryptocurrency will be regulated in the future because a favorable decision in the case will set a legal precedent and clarify the industry's future course, fostering innovation while safeguarding investors. Garling has committed to continuing to interact with lawmakers and regulators. He emphasizes the need for open and honest communication with regulatory bodies to establish clear standards for how cryptocurrencies should behave within the current financial system. He asserts that the SEC is attempting to kill innovation and the cryptocurrency sector in the United States, and that the Hyman speech isn't about any one token or any one blockchain, but rather about general blockchain technology. The general approach to the cryptocurrency company and the documents at best imply, as stated by Garlinghouse, that top SEC officials couldn't agree on the policy and personally urge Bill Hyman not to mislead the public about the rules for crypto. Data that is publicly available reveals that editors were worried that Heinemann's assertion that Ether is not a security would make it difficult for the agency to take a different position on Ether in the future, but he emphasized that while our legal battle was over, for many others the Securities and Exchange Commission sued a cryptocurrency exchange on June 5 for allegedly trading unregistered securities, and the next day, the agency filed action against Coinbase for the same reasons. In light of these allegations, Ripple is alleged to have paid 6 exchangers between $1 million and $5 million to list XRP. David Schwartz, the chief technology officer of Ripple, has responded to shed some insight on the matter. In response to a conversation started by the fictitious, self-styled scam detective, Schwartz provided more details. Scam investigator, if this came from the SEC itself, some supporters have said it would be game over for the agency, but Mark Fagel, a former attorney for the SEC, has said unequivocally that the SEC did not author the paper. Scam detective has recently tweeted about this as there are reasonable reasons to assume that our XRP does not satisfy the Hawaii test. According to scam investigators, the law firm's finding that xrp is not security was partially corroborated by the fact that Ripple does not enable xrp trade on the secondary market, but recent research found that Ripple spent between $1 million and $5 million to list xrp scams on 6 exchanges in 2017. Detective discovered that the Schwartz clarified the nuances of the situation, emphasizing that the claims made are merely allegations and that the truth is far more complex. Schwartz gave an illustration of the procedures that could support such claims. He went on to explain that Ripple may first decided against paying the high listing fee demanded by an exchange. Archery, the only way that Ripple could use the exchange automatically and force xrps to list on the platform is if it later finds a way to establish a valuable payment connection with that exchange. In that case, it would pay the integration fee rather than just listing xrp. And this payment would help Ripple achieve its larger goal of increasing its on-demand liquidity. ODL serviced Schwartz clarified that this is only speculation and emphasized that litigants frequently made accusations in the worst possible terms. He cautioned against accepting the accusations at face value and emphasized the necessity for a fair evaluation without really contradicting the facts. You may recall allegations that Ripple made payments for transactions in particular. This month's scam investigator asked Schwartz how much Ripple paid for Coinbase to incorporate or reawaken old doubts that were initially published in a Bloomberg article in 2018. The only tale I wish I could share at the moment but can't is the one about the Coinbase list extra. We stop here for now. Please kindly like and subscribe to be updated whenever we post similar videos like this. Thank you.